Hi, folks. Thank you all for joining us today. We're kicking off our new series, Topicality to Reality. For those of you that are just seeing this for the first time, we will be using this series to help you all get a better handle of debate for this season, debating online, but also connecting what you learn in debate to the world around you and criminal justice reform as a topic. Joining us today, we have Jaya from Harvard Westlake and Harvard Debate. She just graduated this spring and debated in Lincoln Douglas from 8th through 11th grade and policy debate from 11th through 12th grade. So, Jaya, how are you feeling about starting college in the fall?
Little anxious just because, COVID's making everything really uncertain, but more excited than anything else.
I'm sure a lot of the debaters are feeling the same, so thank you for taking the time to sort of help guide them through this new world of online and research stuff. And then my second question is, earlier I read a quote from you that you're really excited about doing research. How do you feel about researching and writing cases and stuff?
It's always been my favorite part of debate. I actually think it's the part of debate that translates most into the real world. I've found that researching even things from history papers becomes a lot easier. But when I did an internship this year with the Loyola Project for the Innocent, even research for that became a lot easier and I could get through it much faster, which was really cool to see kind of how debate interacts with the real world.
Awesome. Yeah. Well, glad you're here to sort of show us the ropes on that front. So with that, floor is yours whenever you're ready to start with your presentation.
All right. Hi, everyone. So we'll be going over researching and writing a policy aff on this topic. I think this topic is amazing, so you all should be pretty excited. All right. So let's start with the types of affs. If you should get your Word doc open, I think this was sent out by the Lambda community or on the Lambda YouTube page. So get that Word doc open, and that's a place where you can take notes on this whole thing. So the first type of aff that we're going to go over is called a soft left aff, which is basically a critical aff, but it has a plan. So in this situation, we would be talking about racism and issues like that. But instead of saying that things are irredeemable, we have to not use the USFG ever, instead, we'd be more saying that there are steps to reform that we can use to kind of, change the racist structure around us instead of just wholesale getting rid of the USFG. So that's kind of the first type of aff that we'll be looking at. The second type of aff is what we're usually used to on most topics, which is the policy or hard right aff. And these are the kinds of affs that defend your typical extinction impacts, nuke war impacts, and there are these kinds of affs on this topic, although I would say generally they're going to be less frequent and they're usually not as good in terms of evidence. But if you want to read this and that's really your style of debate, there are definitely ones that you can go for, and we'll be going over those as well. So now we're going to go over the place where I think you should always start topic research, because I think it gives you an idea of where you should be taking your aff and what direction you should be researching. And I think that's topicality. So we're going to start with a couple key terms. There are obviously more terms in the resolution, but we're going to start with the ones that I think are key for researching what aff you eventually want to defend. The first one is enact. And so we want to go over which branch can enact criminal justice reform. If any of you want to take a quick guess and write it down on your paper, or if you know, write it down on your notes doc and see if you can confirm with what I'm about to say. Congress is the one that can enact criminal justice reform. So Congress in this aff situation or on this topic will be passing criminal justice reform through the legislature. So they'll have to go through the Senate, House, and either get checked off by the president or it'll have to have a 2/3 override in Congress. So this means you'll probably be having a good amount of debate about politics, like politics disads. So you want to kind of construct your aff with that in mind as well. And you also want to kind of look at the ways that maybe people could be reading a court's counterplan against you or other types of counterplans. So keep that in mind that Congress is probably going to have to be your actor. Okay. The next section of the topic that we want to talk about for topicality is forensic science, because this is the first big place where you can kind of find your aff. And I went out of order on this accidentally, but the rest of the slides will be in order in how the topic is worded. But forensic science, you should look at your Word document. It has a definition that I've put in there, and it's basically a bunch of different things. It's essentially just the types of evidence that we present in court that would then be used to accuse somebody of having committed a crime. So this situation, it would be like DNA analysis, or it could be like bite mark analysis or footprint analysis. There are tons of different things that fall under the branch of forensic science, but it's just evidence that gets presented. The second place you can look for your AF is policing. Again, I've put what I think is probably a good topicality definition in the doc that you should be reading through. But essentially, policing is just police practices. So when police are out on the street, what can they do? How do they arrest people? What are their methods of arrest? What kinds of, immunities do police have? What can police do, etc. Also, a very kind of broad area. And so then we get to our third and final one, which is sentencing. Again, you should refer to the Word doc. I put what I think is the best definition in there. And so sentencing is just what happens when somebody does get convicted. So this means they've gone through the whole process. Either they take a plea bargain or they, get a jury trial and the jury finds them guilty. What happens then? How much time do they spend in prison, or do they have to do community service, or what do they have to do? And so there are tons of different sentencing guidelines. There are things like mandatory minimums, where if you're found guilty of a certain charge, you might be forced to serve a minimum sentence. And there are also things that give judges more discretion. So maybe do we want to give them less discretion? There are a ton of different places where you can go with this. And the definitions that I gave you are by no means the only definitions out there. You should be researching your own definitions as well. But these are good starting points, I think, and should hopefully help give you an understanding of the topic at the very least. So I think that after you kind of, figure out topicality, determine what is topical on this topic, figure out places where you can go with this, what are the places that are most relevant to this topic, what is even in the purview of the resolution most likely, you should find the core areas of controversy. And what I mean by this is, instead of looking for the tiniest, fringest little AF you can at first, you should generally be researching kind of the core tenets of each of these three areas of the topic. And that'll give you the best starting point for dealing with the topic. Otherwise, you might get too caught up in really minute research, which doesn't end up becoming super relevant in the long term. So I'll give you a few examples of the places that I think are core areas of controversy in each of these different sections. Let's start with forensic science, since that's apparently my favorite part of the topic. The first part of forensic science that's kind of important is DNA. And this is what's becoming more and more prevalent. So there are different types of DNA tests. I don't know exactly what they're called, but I think there's YSTR. There might even be an STR without a Y in front of it, but there are different acronyms they use for the tests. And so essentially DNA gets run, and there are a couple of different kinds of tests that can be run. You'll eventually, if you run this AF, you'll probably want to learn the difference between the different tests. So one, for example, can distinguish between males, but not distinguish between females. And there are a couple other different types of tests. The important thing that I found about these AFs in the literature is that they get uploaded, that if you are arrested at all, even if you're not convicted, even if you're not charged by a prosecutor, your DNA still goes into a system called CODIS. And this is the FBI system that takes our DNA and stores it. A lot of people have accused CODIS of kind of bolstering racist practices because they say that CODIS is, first of all, we know that the majority of people who get arrested, unfortunately, due to racial bias in this country, are people of color. So this means that people of color are more frequently in this database than other people. But secondly, because DNA is fairly accurate, but it's not always accurate, it means that the majority of the time when DNA is wrong, it's wrong in the cases of people of color. And then lastly, people accuse CODIS of kind of resulting in the targeting of people of color because they think that police will just take them in and book them, but not actually file any charges just so they can get their DNA on file because they think they're future criminals. A lot of people have privacy issues with this as well. So I don't know if any of you have heard about the conflict with 23andMe, where they're uploading your DNA into a database, and people got really upset about that because DNA is something really private to us. It's that's one of the things that can be determined. That's this is you are DNA. And so uploading it into the database, people have a lot of privacy issues with. So there are a ton of different proposals for this app. Some people say get rid of CODIS altogether, which is on the more radical side. But there was also an app turned out at the Michigan camp that said that we should cause automatic deletion of DNA from the file for people who have been arrested but not charged with any crime. And so that would kind of resolve some of the racist issues we see of cops booking people just to get their DNA on file, but never charging them with anything. Okay. The next thing under forensic science is kind of a personal favorite of mine, is the conviction of innocence with faulty forensics. And so one of the places I think you can actually look toward this is on Netflix. There's something called The Innocence Files, which I think is a really interesting documentary. Even if you don't want to read this app, you can take a look at it because it's definitely going to be relevant to the topic. But it goes through the ways that innocent people get convicted due to forensic scientists using really bad, basically just bad science. It's not real science. It doesn't apply to anything, and it's not proven. So the examples gone through in the Innocence File is like bite mark analysis. And this has just been proven over and over again to be a flawed method of analysis that does not result in accurate convictions because it's just not something that you can compare. You can't compare one person's bite mark on his skin to their teeth. And so that's been a major source of controversy, and is something that like I personally know about because I did work with, as I said before, the Innocence Project over the summer. And so I think this is a really cool area that wasn't explored a ton at debate camps that could be really innovative for you to look through and has a ton of literature and is super cool. Okay, now onto policing. The first major policing app, I think, is obviously the place where most of our minds go when we think about criminal justice reform, which is lack of accountability for racism for police officers. So all of you, I'm assuming, know about the George Floyd protests and probably all of the other things that have led up to that. So we have a ton of instances of like Black people being brutally treated by the police, and we need to find some type of way for society to hold them accountable. So in Los Angeles, there have been like a couple hundred, at least maybe 600 cases of police brutality, and only like, I think 3 or like 1 to 3 have been charged by our district attorney. And so this was in Jackie Lacey's time in office. And so we're starting to see that like cops are really not being held accountable. And we're seeing this more and more in the media as people can post more about it. And so a lot of literature has come up around this and even existed a long time ago, but we have a lot of people who now agree that like something needs to be done about the police. We need to either defund them, we need to put more accountability practices in place, maybe get rid of qualified immunity. These are all different areas that you can research, but we need to find some way so that police who are engaging in racist tactics can be held accountable for these tactics and therefore maybe decrease the amount that police engage in racism. There are obviously arguments that say police are racist no matter what, but what you want to say with this app is that we can reform policing such that we can minimize racist impacts of policing or get rid of it just through training. The next major area of policing, I think, is like marijuana laws, for example. And I think this is a great area because it's so controversial in certain states, but in other states, it's already passed. Like we know New York has decriminalized like weed consumption. So we think that different states. And so I'm in California, which is very liberal, and I'm assuming all of you are too. But in California, we have like generally lax marijuana laws. But I think that this is one area where you could focus in on because some states still don't have it. And we might want a like federal policy that just makes it uniform across all the states so that we don't have different laws between different states. And that way we can kind of like resolve the issue of marijuana. And a couple of reasons why the policing of marijuana has been really bad is because it's often been targeted at Black communities or like other communities of color. And these communities of color are disproportionately like put in prison and stuff because of, you know, the way they use marijuana. And so in this situation, the way you'd want to reform policing of marijuana is to either say that police can no longer arrest people for using marijuana, or a couple different, like there are obviously a couple different apps. That's one example. Another example I can give you is to say that police cannot like find or like look for marijuana in cars or like on people. So get rid of stop and frisk basically. For marijuana, for example, or get rid of stop and frisk overall and say that it solves the issue of like looking for marijuana on people. Those are just a couple of examples. The next area that we want to look at then is sentencing. The first major area is very controversial, and you all probably know about this just because it's something that's like always been controversial for a long time. It's the use of the death penalty. And so more and more people are turning against this. Like our generation is probably the most against it that we've seen from the generations before us. It's kind of been a trend like that throughout history. And so the death penalty is something that a lot of people think we should get rid of for a couple different reasons. First, I think it's a wildly inaccurate way of prosecuting people or sentencing people. And so I think they've found a statistic that's like for every 9 people on death row, 1 person has been found innocent. And that's an absolutely absurd statistic for people who are being sentenced to death. And I think that the other thing that people want to say on this topic then is just like the death penalty is just immoral. We shouldn't be creating a standard that's like we should kill people. It's not like our society is getting anything by killing people. Like maybe we can like lock them away or get them help or something, but like putting people to death, especially when there's that high of an error margin, is not acceptable. There are also potential ILAW or international law advantages with this one, because a lot of people frown upon the US for using the death penalty. So countries in Europe, many of them got rid of the death penalty because they're like, this is not moral. This is not something we should be practicing. It's a violation of human rights. And so it looks bad for the US to keep pursuing it, especially because you've got really good uniqueness on this app, because like the first man in I think 20 years was killed as a result of the death penalty. So that's something very recent that you can look into. And so there's probably a lot of literature on ILAW right now. The next area of sentencing is drugs. So we talked about marijuana in the context of policing and how do police engage with drugs. But in the context of sentencing, this would be more attuned to like worse, harder drugs. And so we're talking about like heroin, meth, that kind of stuff. And maybe we'd want to say that the sentencing for those types of drugs should not be as strict in certain circumstances. So there are situations where we've seen people go to, and oftentimes actually, not even situations, oftentimes people end up going to jail for absurd amounts of time after just maybe carrying like one, drug, I don't know what they call them, but like carrying drugs from one area to another area and being a mule, which is what they call them. So maybe that's like a term that you would want to look up if you're researching this app. But they get put in prison for absurd amounts of time, while the kingpins who are at the top of the drug hierarchy don't end up ever getting like any time. And so these could be people who were coerced into the situation to become a mule, who were unwillingly mules, and they go to prison for like 20, 30 years, which is insane. Because oftentimes, again, and this is a like common trend that we'll see throughout this topic, these are people of color. So hopefully that kind of gives you a general idea of where you can go in each of these areas. If you were totally lost before, hopefully this gives you a jumping off point. And if anything sounded particularly interested, research that. All of these like sound really interesting. For me, I was the most interested in the conviction of innocence because that's something I worked with. And so if I were researching this topic, I'd be like, that's really cool. I'm going to start researching that. So take any of these or any other ideas you might have come up with on your own and just start researching, because this topic is so large that I promise you there's literature on what you want to research. Okay, so now to kind of go over, what does a soft left versus a hard right AF look like? And so we're going to go over the ways that you want to construct your AF, just in case you're feeling kind of lost about how you would even write an AF in the first place. So for a soft left AF, the first thing you want to do is identify a small impact that you definitely solve for. So let's take the stop and frisk AF as an example. In this situation, we would say stop and frisk causes massive trauma to people of color who are just like, their bodily rights are violated on the streets when they're stopped for no reason. It's dehumanizing. Now, a lot of people would be like, that's a pretty small impact. It's not like nuclear war. You're not saving a ton of lives. Most people don't die as a result of stop and frisk. So, but like, and that makes it small, supposedly. We could obviously argue over what I mean by small, but in this situation, I mean number of lives saved. But the important thing is by ending stop and frisk, you would definitively solve for the impacts of racial trauma that occur as a result of stop and frisk. So these AFs, you definitely want to have really strong solvency for them, because you're going to be able to leverage this eventually when you're like weighing the AF versus disads, and you want to be like, or even counterplans, and you want to be like, our AF definitively solves for this impact. Even though their impact might save more lives, it's always going to put things on the back burner, which we'll talk about in a second. But this is where we get to the kind of complicated part of soft left AFs, which is you have to win structural violence outweighs. Because in your mind, you're probably like, well, if somebody reads an extinction dissad against me, how am I supposed to use racial trauma to like outweigh extinction of everyone dying ever? Well, there are actually a ton of different ways to do this. And this was something I did all throughout my senior year. And it's probably like my favorite type of AF to argue. The first thing that you can say is that structural violence, or basically structural violence. Sorry, I didn't explain that term. It's just the type of violence that occurs on a day-to-day level as a result of structures. So racism, for example, is a part of a structure that's used to oppress people of color. Structural violence is the same thing as systemic violence, if you've ever heard that term. And it's just the type of violence that occurs on a day-to-day basis. So the first type of impact weighing claim is structural violence accumulates over time. Also, sorry if you hear my dogs barking in the background. But what you would say with this is that even though something like a nuclear war or whatever they try and say on the neg causes a lot of death, our type of violence that we're talking about adds up. So their type of violence is a one-off event. Everyone dies. There's not that much pain and suffering. It's just like you get dropped a bomb on you and like everyone dies, but it's just something that happens once. Versus structural violence and the pain that minorities have to face keeps adding up over time. So if you're using a utilitarian calculus, you can even win under a utilitarian calculus and say that all of this violence eventually adds up to way more and be more important than something like a one-off event like nuclear bomb being dropped. And so this is a clever way to get around a judge who's like, I think lives and, happiness and util is always the thing that matters the most. This is a way you can be like, but look, our impact is utilitarian. But I think the better argument comes in here, that large-scale impacts put minorities on the back burner, which is kind of what I was saying before. Essentially, when they get up and say, there's going to be mass extinction, etc., our argument on the AF when we're reading a soft left AF will be, but there's always going to be another crisis. So they're trying to say, look, the AF might be a good idea in the abstract, but when we try and implement it in reality, it's going to cause extinction, and extinction is just matters so much that we can't do the AF. And you want to be like, but extinction's always going to be an excuse. For every single type of change that we make for minorities, people are always going to use extinction or, oh my God, it might collapse the economy as a justification to not do it. Our point is that minorities we need to just prioritize them above everything else and just finally start addressing inequality. And so a good example is, and I'm sure that you all have learned about this, the debate over slavery. So you look to slavery and a lot of people were like, but if we get rid of slavery, it's going to collapse the economy of the South. And then everybody in the South is going to suffer and there's going to be a massive war. And there was a war, like a civil war. It's debatable over what caused it, but at least people will say there was a war. But we want to say that the suffering of slavery and the amount of moral wrongness that comes with slavery is far worse than the Civil War. The Civil War was fought because slavery was wrong. And at some point we just had to get Black people out of chains. Similarly, you want to be like minorities and people of color never get addressed. They are always told, just wait your turn and eventually you'll get what you want. But they never end up getting it. So at some point, the judge just needs to hold the line and be like, it is time for us to address minority issues. A good example of this is the CODIS AF about racism. And so I think that the way you'd want to construct this AF is by saying, currently, minorities are being arrested disproportionately so that their data can be uploaded into CODIS because they're viewed as threats, and the police want to try and get them on some other charge in the future, and the police thinks that they're going to commit a crime for some reason, and it also causes a lot of wrongful convictions. In this situation, you could say something like getting rid of CODIS or forcing automatic deletion of DNA samples after somebody has been released from custody and not charged. Those are all ways to resolve the impacts of racism, because it would mean that police wouldn't just go randomly stopping people and charging and arresting them for no reason if they knew they couldn't stick a charge. No longer would there be those racist policing practices. And that's a really good example of that is concrete solvency for a small impact of racism, of people being, going through the trauma of getting arrested. But it's enough for you to win. That is something important that should be addressed and is something that people are talking about. But for those of you who are like, I still don't get it. I just don't think that it could ever outweigh extinction. And I love reading extinction AFs, hedge good, that kind of stuff. There are definitely asks for you on this topic. So what does the construction of a hard right AF look like? This is going to look a lot more like the regular, AF construction that people tell you about. Let's start with inherency/harms. I'm putting these together because it makes sense kind of. But essentially, some massively bad thing is going to happen right now. And the example I'm going to give at the end eventually is about a drug war. And so If you wanted to read an aff about drugs and sentencing or drugs and policing, you could say, a drug war is going to come now. It is going to kill thousands of people. It's going to escalate because states will get involved, and then states will use nuclear weapons. Those are examples of like different claims you could make for your advantage. Then you want to say solvency. The plan is key to stop that massive impact. And so what you could say is decriminalizing all drugs is necessary to prevent a drug war. We can come up with other tactics in the future, but the drug war is imminent, and we need to stop it right now. So that's our solvency. And then we have our example of the drug war. And so I don't think there are that many apps on this topic that can be hard right. I think generally you're going to end up talking about racism. And I actually think that is the direction this topic should go in, because that's kind of what is most pertinent right now. Like, we're living in an unprecedented era that this is the kind of thing that we should be discussing, whether it's like COVID and the racist impacts of that. Like, we've seen a lot of articles about that. I don't know if that could play into the topic a ton, but we're also looking at like the George Floyd protests, as I mentioned earlier, not to sound like a broken record, but clearly that is something that we should be addressing. But if you're just like a diehard hard right fan, then there's an app for you as well. So if you're still lost and you're not totally sure where to start, there are two resources that you can look to. The first one I provided is a University of Michigan starter set. I think this is a really valuable resource, since the like UMichigan debate camp I went to in my senior year, they were like really good at cutting evidence. The coaches there cut a lot of evidence. The students there are really devoted and spend a lot of time researching in the UMichigan libraries. So I've always thought very highly of their evidence. The next one you can look to is the OpenAv Debate Coaches one. And this has all of the different camps, all of their evidence. Michigan is not on there yet, the last time I checked, which is why I provided that link separately. But there are other camps on this, like the Dartmouth camp, and those camps also have evidence on there. So if you're just totally lost on where to start, then you can look to these places for ideas of AFs or NEGs that you may want to run. So we are going to open the floor for, does anyone have any questions?
Can you hear me? Just had to unmute myself. All right, awesome. Oh. I was muted in 3 different places. All right, awesome. Thank you for the presentation and direction. There were some questions that we did have lined up.
Amazing.
So let me go ahead and start with those. So I guess we'll go to where you started with your presentation when you were talking about actors and things like that. I know you said that most of it will be sort of congressional legislative based, but what do you think about things like executive order counterplans, and is it strategic to sort of design an AF with that in mind?
Absolutely. That's a very good question. You have to design the AF with those in mind. So I do think executive order counterplans will be like prevalent on this topic. Do I know if they're topical? I don't probably think that they're going to meet enact or like T enact, which is why they're probably neg ground. But if you can find a definition of an act that talks about the executive or the courts, that's fine, although I don't know if they exist. I think almost all definitions say Congress. So the executive order counterplan and the courts counterplan are both negative ground that you need to be able to beat back. A couple different ways I think you can do this. The first way is obviously Congress key warrants. And the reason why you'd want to say that is that, for example, executive orders don't get enforced. Trump doesn't care about executive orders, that kind of stuff. Or for the courts, you'd want to say courts like get interpreted incorrectly, like even a Supreme Court decision doesn't get enforced that well. Or you can just be like, there is no way that our specific AF, and like you would have to find evidence that's like, there is no way that a court could rule on this because it's not a legal interpretation matter. We'd have to create a totally new thing of law. So for example, with like drugs, I don't really think there's a way that the courts could like rule on this because there's like the courts probably would, I don't think there's any evidence saying that the courts would say that drugs are legal. Although I think a better example is like, I don't know, I'd have to think about it for a second, but I think with policing practices, maybe like you would want to say our specific policing practice is not a matter of legal interpretation because the courts can only rule on things that can be legally interpreted. But if it's a law that requires to be made, then that's a Congress only warrant. The second way I think you can deal with these is like obviously theory. So I'm not going to rule that out. So we'll say that really fast. The third way I think you can deal with these though is explaining why Congress would eventually have to get involved at some point due to enforcement mechanisms. And so that would be like a good permutation argument that's like, even if the courts or the executive could rule on it, Congress at some point would need to do something in order to ensure enforcement. And that was an argument that we made a little bit, but it's going to require definitely some research.
Awesome. Cool. Let me pull up the next one. Oh, so yeah, how would you? So I know a lot of our students are interested in sort of talking about the topic, but they're mostly affected by it on the sort of local, sort of city and state level, right? Is there a way to sort of create a topical AF, but that sort of starts from the place of local issues?
Absolutely. I think there are a couple different ways to do that. I think the first way to do it would, so all of you, I don't know if you've done research on this, but if you've ever heard of the Rodney King riots, that was something that occurred in LA and spurred national change. So what you would want to talk about then is how there's something going on in LA that's like really just disgusting and like awful and we should not be having it. And then say that that should be our inspiration for this law for national change. So I think what you can do is kind of like a spill up claim almost, which is like, we're going to talk about LA and only make your advantages and like that kind of stuff about LA, but then have it be a federal policy because you can be like, LA's struggles are connected to other cities' struggles. If you look up the Rodney King riots, I think there are a lot of parallels with like other things we've seen in today's society, where there have actually been a lot of cases in LA of police violence that have spurred national outrage. And you want to say because LA is such like a focused in like it's hyper visible, like everybody knows about it. And because it's so hyper visible, other cities across the nation use us and like look at us and see us as an example, and they're all experiencing outrage as a result of what's going on. So that should be the like framework that we use to decide what national change we should make. Really fast, I do think you run one risk with it, which is, and this could be like with anything, there's a state's counterplan that would probably also be negative ground. And the state's counterplan would just be like, do it in California and then read politics as a net benefit, or even just do it in all 50 states and that's a politics net benefit. There are obviously ways around that though, but I think it's a really good place to start with in LA, and talking about personal experience could even be brought into a topical AF. Like, do you talk about personal experience?
Awesome, thank you. Jason had a follow-up question. So he asks, are court apps completely off picture for being topical? Or is there a way to sort of like find a definition to defend that?
I'm sure you can always find definitions, without a doubt. So I haven't done enough research on Enact to be able to like dig deep on if court apps would be topical. But I'm sure there are ways where they could be topical. I don't know if it would. I bet most people who read T and Act will fall on the side of thinking only Congress is topical, but like there have been more egregious non-topical AFs that people have won on T against. What I think you can say for a court's AF is exactly what the court's counterplan would do. You'd want to say that for an issue, for example, like qualified immunity, which is basically where police officers have immunity from being sued civilly by citizens, then the court could rule and be like, that's not constitutional. All people should be allowed to be sued. We all have like certain rights under the Constitution or whatever. That is an example of an AF or a counterplan. I think you're going to have an uphill battle there, but honestly, if you do enough prep on it and you cut some good cards that are like enact is the courts, or criminal justice reform can only be done through the courts, then you're in a good position. Oh, I think you're muted.
And I'm back. All right, thanks for catching that.
Yep.
So the next question sort of has to do with when you were talking about structural violence and util and things like that. They ask, do you need to read new evidence for this that's like specific to the topic, or is it safe enough to read some back files on framework stuff? And should it be in the 1AC or the 2AC?
That's a good question. It's always safe to read back files. So I'll give you that like short answer where if you're just really pressed on time, it's the first tournament and you're just like, oh my God, I've got a ton of homework or I had a test last week and I just can't prep this out. Go ahead, read back files. But what I will say is I think the more specific cards for this topic, I think the cards about criminal justice reform and structural violence are so good about how things always get put on the back burner because we're like, oh, but national security, or like, oh, we really need to stop crime. I think those cards are just so good that you shouldn't be reading back files, if that makes sense. Well, I think that you want to have a mixture in the 1AC and the 2AC. I think you want a good amount. I think you want the majority in the 1AC, your best cards. And so I would have, my rule of thumb is to have one critique of counterplans. And what this would look like is saying that representations shape policymaking. So any counterplan that's connected to a disad with some type of large scale impact or like crime impact or something like that, the implementation of the counterplan gets also done in a racist way because of the representations that are associated with the disad. So one critique of counterplans, one critique of like disads in general. And so this would probably just be a card that's like either something that's like structural violence should always come before everything else. But in this case, I think you'd want to say criminal justice reform should be prioritized above safety of citizens because we're just in such a bad state right now. And then in certain situations, you're going to want to put K preempts in that are like material changes are necessary. And so this would look, I don't know about what they would be on the criminal justice reform topic. Obviously, there are tons of cards that say material changes are necessary and like we don't have to get rid of the whole system. Sometimes I remember finding a couple of those when I debated on qualified immunity. A couple of those I think were in response to a book by Michelle Alexander. If you want to like look for responses to that book, that could be a good place to start with like material or incremental reforms. But your generic card would look like the Matsuda evidence or the Delgado evidence. And so I think those three are your rule of thumb. But you probably want to have a couple more in there, maybe a critique of politics. Like there's a Tickner piece of evidence, which is pretty good for that, which is just like politics is viewed as trading lives for like policies, which is super immoral because lives should matter a heck of a lot more. And we shouldn't just be trading lives. So I always had about 5 preempts in my AC, 2 disad cards, 1 counterplan card, 1 K card, or that would get replaced with a disad card, and then 1 K of politics. And then in the 2AC, depending on what they read, I would usually try and K every disad. So whatever they said, if it was like a nuclear war impact, I'd read a specific card about nuclear war. If it was a crime impact, I'd read a specific card critiquing the notion of crime. And that's kind of how I dealt with like saying structural violence should come first and their impacts are immoral.
Awesome. Thanks for that outline. That's definitely going to be helpful, especially in the early season. I know a lot of teams are going to try to fall back on some arguments that they already know, like a crime disad and things like that, that are generally weak arguments that should just sort of be like addressed on face from a framing level.
Yeah.
So, it's definitely good and important to structure your AF around. So it seems like for the folks that are on live right now, that a lot of them are directing their AF to be soft left AFs. So their questions are about sort of block writings. What off-case arguments do you think they should prioritize for their first tournament?
The problem with this topic is there's no generic disad. So it sucks for me to have to give you this answer, which is like, you're going to have to prioritize whatever you think is the best argument against your AF. But I think, and one of my coaches at Harvard, I'll have to give like him credit for this. But he says that the way, or his name's Vivith, so I'll give him credit right now. But the way that he told me to think about AFs was you want to structure your AF basically thinking, what is the most likely 2NR? So what seems like the thing that most people are going for? What is the best 2NR against my AF? What do you personally think? And what does your 2N partner think is like the best, most silver bullet argument? And what is the first 2NR they're going to read against your AF? And so this would be like off the top of their head, if you're breaking new, what's the first thing that they're just going to pull up and throw against the wall to try and debate you with? So I think you want to structure it around those 3 things. As for hopefully more concrete, like what I can tell you how you should be block writing, I always kept a couple of different blocks in my back pocket. obviously for all of those preempts, I had very specific blocks that I could extend every time. So the blocks that I would always have, like the way that me and my partner did it was we had a 2AC generic file, and that file would get copied every round such that like every block from that file would be in my speech doc. So those blocks were first, structural violence outweighs, and that was the accumulation claim plus the back burner claim. That would be in every 2AC of mine. That would be my case weighing claim. So just like how with a policy F, you'd be like, our impact outweighs, 1 is magnitude, 2 is time frame, whatever. In a structural violence F, my top would be like, our case outweighs, first is accumulation, second is the back burner dissat, or something like that. The second block that I would always have is a counterplane critique block. And so this would be what I was telling you about, where we'd say that rep sheet policymaking, the counterplane gets implemented in a horrible way because of the way that the dissat works. And then the last thing that I would always have in my back pocket is like condo. So that should be in your 2AC, obviously. The most popular arguments on this topic are probably going to be, agent counterplanes are probably going to be popular, except I just don't know how much the agent counterplanes can be applied to every AF in every area. So it seems like from the way that I've researched this topic, you're going to need a different strategy based on policing, forensic science, and sentencing. So I don't think there's like any one way to prep this. The one argument that can be applied to everything is obviously like the abolition K, which is just get rid of criminal justice at all. Like it's totally screwed. The whole system sucks. We need to just override it, create a new thing. So you're gonna need a block against that. And what I would say against that is a lot of the material change stuff that you're gonna say is like really important there. You need to go for the permutation, make the no link that's like, we never said the system was redeemable. We just want to alleviate suffering in the meantime. And so those are the kind of strategies that I think you should go for against that one generic argument.
Cool. Appreciate the insight on that. Our next question. Oh, so I was curious about your work with the Innocence Project, but also, so let's start there. So what was the kind of stuff you were doing with the Innocence Project?
So we have a ton of different clients who we all believe are like wrongfully convicted. So we read through their letters and we kind of like screen their letters, seeing first, are they actually making a claim of innocence, which is distinct from being like, oh, like this person was lying and like one of the people on the witness stand was lying. That's not a claim of innocence because that's already been something that's been presented to the jury. Well, it is a claim of innocence, but it's been something that's presented to the jury, but it's not something that we can necessarily evaluate because we need new evidence. So a lot of times this ends up being DNA because that can be really easily used to prove somebody wasn't there. Somebody just wasn't at the crime scene. But specifically this summer, I worked on two things. I worked firstly on I actually worked on three things. I worked firstly on reading through like certain legal briefs and stuff like that to create summaries to make it easier for other lawyers to go through them who are actually arguing the case. Secondly, I transcribed things that needed to get done. And then thirdly, we worked on creating information about the district attorney race that's happening in Los Angeles this year between our present district attorney, Jackie Lacey, and San Francisco's old district attorney, George Gaskin. So those were all very interesting.
Cool. And let's say it is a fiated world, right? Like, is there an affirmative that the folks at that you worked with at the Innocence Project might advocate for?
100%. Oh, yeah. I would say bite mark analysis. Oh, Sorry,
what might that be?
Oh, yeah. A couple different ones. Bite mark analysis is huge, especially after the Innocence Files came out. And that was the thing that I was talking about on Netflix. Tons of articles on that. There are also other types of analysis that people think are skewed. So like footprint analysis has been disproven, for example. They're really like niche areas that you can look into. I think one of the things that we can also look into is, this isn't forensic science. It would probably have to be a method of policing, and I'm not sure if it's topical. But there are a couple different main ways that people get convicted, wrongfully convicted. People who are lying. So we would like go to prison, look for a snitch, and the snitch will say whatever to just like try and get a lessened sentence. And so they'll just like pin it on some random person who wasn't even there. So snitches who use inaccurate information, that would either go under, I don't know if it qualifies as forensic evidence, to be fair though. Another forensic evidence example, I couldn't think of it off the top of my head because a lot of the things that we deal with are not probably in the purview of forensic science, maybe in the purview of policing, like what I said over there. Like maybe finding witnesses is in the purview of policing. But those are a couple of things I was thinking about. I would definitely suggest watching the Innocence Files if you are interested in any of those apps, because that is almost entirely about forensic science.
Awesome. And then just one follow up question there. So when we're thinking about creating an app, we're always thinking about it in terms of its strategic purpose in debate. Are there reforms that might be good to learn about, but that aren't necessarily a strategic affirmative?
Oh yeah, for sure. I think so. The examples of forensic science are like really niche. That's a strategic app because it's niche. What you do want to learn about is, in general, policing reforms to try and make them more sensitive to racism. Like ending stop and frisk is pretty or ending stop and frisk is probably a bad example, but like I don't think, to be honest, I don't think that ending CODIS AF is a very good idea about like ending the DNA database. Because I think it leaves you open to a lot of different problems that like it's probably a good idea for like certain criminals to have their stuff in the database. But I do think researching the ways that CODIS gets used in like really skewed ways against criminals, and like researching how like people of color are disproportionately impacted by CODIS could be one example of something that's like really interesting and good to know about, but probably wouldn't make a great AF. I think that policing AFs are really popular on this are going to be really popular on this topic because they have a ton of literature. And naturally, because they're more popular, that makes them less strategic because people are going to inevitably have a case nick against what you say. But like, no matter what you do, you should be reading about policing just because it's going to be huge on this topic. Now, what I will say though is don't push yourself to like go outside of the realm of like, what you were researching, because sometimes it can get really exhausting, and like staying in debate is really important. But you're going to be creating case negs to all these really popular AFs. So like remember that when you're writing these case negs, you'll inevitably be researching the AF and the neg positions. So I don't think there's any AF that's not going to be covered in your research for case negs that you would otherwise want to cover just as a result of getting like educational knowledge.
Cool. And then what was that database you're referencing about the DNA? How do you spell that? Just so folks can look it up.
CODIS. Let me go to it. CODIS.
Cool. Awesome. Great. Yeah, I think that's all the questions that we had, but thank you so much for taking the time today.
Of course.
To do that and hang out with us here. Good luck in the fall. Going to be looking forward to following your career over at Harvard. For the folks that are watching, we'll be continuing this series next week at 4 p.m. With Kenji Aoki from Harvard, who will be talking about the Abolition Project and what does it mean to abolish. So if you weren't able to get the worksheets, let us know, but links are posted in the description. Stay tuned for our season calendar. We'll be posting that later this week. Get in touch with your coaches so you can start getting registered for your first tournaments online. Okay. Thank you all, and good night.